Institute, and I'll be moderating this event as well as moderating and giving some brief comments after the papers. So we have 4 papers today on this panel, which is called Civil Society in Russia, From Above and Below. And because we have 4 papers, we're going to begin right on time, I think. And each paper giver will have 15 minutes to present their paper. We'll move right through all 4 papers just to be sure that everybody gets their time. And then we'll move into a discussion. I may start out with a few comments or questions quite briefly, and then we'll open the floor to the members of the audience. When we get to that point, you can either put any question you have in the chat box, or you can do it orally if you either send us a chat to let us know that you want to do that, or put your little blue hand up in the participants panel. So I'm going to begin by introducing our first speaker, who is Arina Dmitrenko from the University of Toronto. And the title of her paper is Federalism and the Rule of Law, a discussion of Putin's re-centralization policy. So go ahead, Arina.
Thank you very much. Let me just share my screen here. And can everybody see that? Yes? Okay, wonderful. So good afternoon, everyone. Thank you for joining to listen to the panel. Special thanks to Dr. Joan DeBardeleben, I hope I'm pronouncing that correctly, for moderating the panel, other presenters, and Carlton for hosting. My name's Arina, and in the next 15 minutes, I'll cover a topic which I titled Federalism and the Rule of Law, a discussion of Putin's re-centralization policies. And if not yet obvious from the title, I will discuss the ebb and flow of federalism in Russia and its relationship to the rule of law in the country by examining Putin's efforts to re-centralize the Russian Federation after the dissolution of the Soviet Union. And for context, this research was conducted for a class titled Government Law and Politics in Russia, and the presentation was created with the incorporated feedback from Professor Peter Solomon. So let's begin. I'll present the research question I asked. So I asked, what role do Putin's re-centralization efforts play in Russia's continued desire to establish strong rule of law? What effects do Putin's re-centralization efforts have on federalism and the rule of law? And I asked this question for the following reasons. Moscow has sought to grow closer to sort of democratic rule, pledging to leave its imperial and Soviet legacy behind. The rule of law has been deemed rather weak in Russia after the Soviet collapse, and the dissolution of the Soviet Union brought forth a period of change, and Yeltsin's presidency exacerbated some of the existing problems by experimenting with decentralization. And the importance of the question is essentially, I wanted to make sense of the reforms and how they tie into current events. For example, 2020 constitutional reforms. And then the second point was to gain deeper insight into the function of federalism and the rule of law and impact on political developments in the Russian Federation, impacts on citizens as well. So now that I've provided sort of the bare bone thought process, I will present my argument. And I argued that in the absence of long-reigning structural thought regarding the rule of law and its entrenchment in institutions, Putin's political expediency takes precedent over, my apologies, over constitutional governance. And as a result, political expedience acts to shape and reshape federalism through perpetual cycles of reform, leaving the rule of law and federalism rather inconsistent. But before I get too deep into the research details, I want to give you all a sense of how the presentation will unfold. So there's the presentation structure, and that's the order I'll be going in. So let's begin with terms and their working relationship.
For emergency measures, we don't see them wanting to pay their companies that are fulfilling their obligations.
Okay.
Somebody needs to mute their microphone. Thank you.
Okay, wonderful. So terms and their working relationship. Federalism in its nature attempts to strike a balance between the center and peripheries, and to oversimplify its role as an organizing principle, it creates multiple orders of government. But federalism as a theory and in practice are sometimes rather different. And one interesting thing that Elena Chebenkova does in her research is relate federalism to the theological covenant by stating that covenant has, quote, two pillars that are central to our contemporary understanding of federal systems. The first is the constitutional interactions among the constituent units, and second is their sovereignty. And this notion of covenant gives rise to constitutionalism and legalism, which is rooted in democratic thought. And we see a similar reasoning in Jeffrey Kahn's analysis as well. So turning our attention to the rule of law, as Brian Tamanaha noted, some define the rule of law as something that encompasses the social, economic, educational, and cultural conditions under which man's legitimate aspirations and dignity may be realized. Or to put in more concrete, simple terms, it's particular laws which apply to all citizens governed by them. So the way law interacts with federalism is that the proper operation of a federal system requires strong law, because federalism implies at least two levels of governance with their own legally defined powers or areas of jurisdiction. So federalism requires a legal order, whereas a legal order doesn't necessarily require federalism. So jumping to historical overview, and the image to the left is a Makovsky paint. It's an oil painting, which I thought was just an interesting addition to something to look at, basically, which is always good fun. But shortly after the 1861 Emancipation Reform, a self-government system called Zemstvo was created, and Zemstvo divided portions of governorates into smaller local level systems and created local organs of government, which had a level of independence and economic jurisdiction. So we see the beginnings of what federalism is in the modern sense of how we understand it today. During Soviet times, federal structure was organized according to ethno-territorial principles. And this meant that titular nationalities had geographically classified regions. Since the rights of union republics and autonomous republics were subordinate to the national interests of the USSR, this organization served to further sort of Marxist-Leninist thought, which deemed federalism as a means to an end to achieving the socialist liberation. And this operated under a highly centralized framework. And this centralized structure was accompanied by a monopoly on law headed by the Communist Party. And in terms of law, the Soviets managed to create rule by law as opposed to rule of law by situating the law beneath the state. And as a result, the Communist Party, which embodied the state, was immune to law, similarly like the Romanov dynasty. And next slide here, I included a map to showcase the regions of federalism in the Soviet Union. Again, also because maps are good fun, so you can see a bit of the titular nationality breakdown and the breakdown in the center there. And so the puzzle posed in 1991, as I mentioned, was the organization was national territorial principles. There was a monopoly on law. Yeltsin's presidency was during an economic turmoil, a period of transition, and Yeltsin commenced these decentralization measures to try to maintain this machine afloat. So post 1991, there were three ways of federalism. Roughly the first one I already mentioned, which is this ethno-territorial principle. Two other models were territorial and local self-management. The territorial principle referred to a strictly spatial division of power, and the model for local self-management presented a highly decentralized model, which focused on the interpretation of the role of local communities within the former Russian Empire and sort of mapped them onto a more modern outlook. So there we go, slide 12. When Putin assumed presidency in 2000, he inherited a highly decentralized system and began with an ambitious yet ambiguous promise to establish a dictatorship of law. And Putin was referring to creating a harmony between the federal and regional law and the Constitution as a solution to the decentralized federalism of the Yeltsin era. And this manifested in his Re-Centralization campaign. Moving on to the reforms and their effects. The first was the harmonization of laws. So beginning with eliminating unofficial asymmetry and to facilitate law harmonization, Putin created a way for him to remove regional chief executives or disband regional legislative bodies in order to remove the incongruencies of law which existed between the region and the center. And this harmonization of law between region and center was, I guess, arguably positive for both centralizing federalism and the rule of law. It sort of worked to remove informal negotiations and loopholes from the law disparities and enhance the power of the center. However, it also deflated the previously acquired regional power. The elimination of incongruent laws was overall, I guess, a positive for legal symmetry. The second one was the creation of federal districts and Palpriade. In 2000, Putin created 7 federal districts, and these districts were created to level the existing regions and their powers under a federal division to be administered by a presidential representative. And these were called Palpriade. They were in charge of overseeing the president's constitutional authority in the districts. By extending presidential power into the regional level, Putin was able to deflate regional power and situate them under a single sort of level district, which sought to create greater unity, possibly promote an idea of unified federalism across the country. And this reform was arguably a positive for federalism and re-centralization, but sort of neutral for the rule of law. And it added a structure that locked the districts closer to the center, and once again cleaned up some of the disparities of the post-Soviet decentralized system. However, once again, this was sort of muffled by a presidential presence. And in terms of rule of law, the effect was somewhat minimal. Then replacement of bilateral treaties with a centralized process, which is connected to the Kazakh Commission of 2004, which focused on restoring a sense of legal order in the multi-level governance system. Fitting into this were a series of existing bilateral treaties between the federal level and the subordinate units, and that again existed as part of the messy dissolution of the USSR. And 47 out of 89 units of the Federation had a bilateral treaty, and they were incongruent with the federal constitution. By 2003, 24 bilateral treaties were abolished in order to decrease asymmetry. And the elimination of these treaties was a positive, so to speak, for federalism. There was less dependence on informal and hidden negotiations, and neutral for law. The fourth we have is the central management of governors. Another reform which Putin undertook was the management of governors during his initial reform sweep in 2000, which was simultaneous with creating the 7 districts that I talked about. And Putin signed a law that allowed for governors to be dismissed by the president. In 2004, he signed a law that said governors would be directly appointed by the president and approved by the regional legislatures. And in 2011, there seemed to be an indirect election through which the president could control the outcome. And that was followed by a number of protests. And this procedure was arguably negative for federalism, since the chain between elected governors and the people was broken by Putin's heavy involvement in their roles. As a result, there was no actual voice that existed in the federated regions. And in terms of law, this provision was not necessarily impactful. However, it likely increased distrust among citizens. And finally, it seems that Putin's reforms were re-centralizing federalism, and their effect on the rule of law was this consequence. In removing the federalism and active federalism as it was before, they subsequently faltered some of the confidence in the rule of law. In terms of harmonization, the rule of law was likely strengthened, and federalism was re-centralized, beginning to build what later become known as the power vertical. In terms of creating districts and Palpriade, the districts, funnily enough, actually coincide with military districts in Russia to a loose degree. But more importantly, the reform extended presidential power into the regions and in a way undermined regional independence. In terms of eliminating bilateral treaties, Putin eliminated these legal loopholes and incongruencies for federalism, and this served again to build his power vertical. And finally, his management of governors. Some have remarked that Putin was in a way turning back to the czarist arrangement of regions with sort of Tsar regions and appointed governors, which is an interesting parallel to make. Overall, as long as the executive continues to prioritize presidential power and creating this power vertical, various reforms can and maybe will continue to shape and reshape federalism and the rule of law, leaving both federalism and the rule of law weakened and confused. And insofar as the state and subsequently its executive remain outside of the realm of law, the issue of this fluctuating federalism according to political expediency might not change. Like Sakharov said, the current principles of federalism are frozen in de jure space, sort of creating a federation without federalism. This is also noted by Chebankova. So it remains to be seen how the rule of law will be strengthened and where it will go under this, so to speak, created power vertical. And thank you.
Thank you very much, Arina, and you stayed very well within the time, and I think you got us off to an excellent start. So we'll now continue with a kind of legal theme, I think, with Alexandra Yao's paper. She's going to be, or presentation, she's going to be talking about the impact of the 2020 constitutional changes on authoritarian constitutionalism in Russia, judicial pragmatism between the Russian Constitutional Court and the state. She's also from the University of Toronto.
Can you all see it in full screen? Is it working?
It's good, yep.
Yes,
Mhm.
impact of the, okay, awesome. Okay. So the impact of the EURUS trials and the authoritarian constitution and the rule of law in Russia. Oh, I can't. Oh, that's the stream. Okay. In 2003, EURUS, the largest private oil company in Russia at the time, was in the middle of merger talks with Chevron, Texaco, and ExxonMobil, and an unprecedented deal which would have created the largest oil company in the world. The other shoe dropped when later that year, EURUS CEO Mikhail Khodorkovsky was arrested on charges of tax fraud. EURUS was sold for parts in court-mandated auctions and through a series of maneuvers, eventually acquired by state oil company Rosneft. Since EURUS was auctioned off at staggeringly low prices, EURUS shareholders suffered a tremendous loss of capital and have since appealed to the international courts. And for nearly 2 decades, the shareholders in the Russian government have continued to overturn and reinstate compensation rulings of a $50 billion payout in international courts. And so my research question is, what are the implications of the recent constitutional changes on authoritarian constitutionalism in Russia and judicial pragmatism between the Russian Constitutional Court, RCC, and the state? This paper is threefold. In part 1, I trace the authoritarian constitutionalism balancing act in Russia since the dissolution of the Soviet Union. In part 2, I trace key developments of the EURUS trials and the immediate responsive constitutional changes in Russia to argue that the EURUS trials were the elephant in the room in major RCC decisions. In part 3, I illustrate the severity of the recent constitutional changes in Russia for judicial independence. I argue that the constitutional changes were accelerated by the EURUS trials and have offset the RCC's balancing act of judicial pragmatism with the state by formally erasing the separation of powers between the executive and the judiciary. Okay. So Arina covered this a little bit, so I will try to speed through it. We have very similar topics, which is exciting. Immediately after the fall of communism, judicial scholars were full of hope for the modernization of the Russian Constitution and federal legislature. The 1996 Russian Criminal Code reflects this by switching emphasis onto protection of the individual and outlining core principles of legality, equality of individuals before the law, and criminal liability based only on guilt, justice, and humanism. Their goal was radical legislative transformation. The initial judicial reforms in the 1990s exceeded all possible expectations, including political competition, free speech, freedom of the press, democratic elections, and other democratic institutions previously non-existent during the Soviet Union. The Constitutional Court was established in accordance with European standards and was the first judicial agency in Russian history with the power to legally evaluate the actions of actors in the highest levels of government, including the president. The law on the Constitutional Court established judge immunity, irremovability, and impartiality to establish judicial autonomy. In 1991, the law on the Russian Federation on mass media declared freedom of speech and the removal of Soviet norms of censorship and ideological restrictions on independent journalism. Inspired by the Constitution of the Fifth Republic in France, the 1993 Russian Constitution followed suit and likewise established a semi-presidential system. The fundamental principles of the 1993 Russian Constitution explicitly recognized the exercise of state power on the basis of separation of legislative, executive, and judicial branches, and the independence of these 3 branches. Articles 118 to 123 went on to establish the immunity, irremovability, and inviolability of judges. This was a remarkable achievement, especially since judicial independence was non-existent under Soviet rule since the courts operated as an arm of the repressive government apparatus. The Constitution also established a judicial system composed of the RCC, Supreme Court, federal courts of general jurisdictions, arbitrage courts, and the Justice of the Peace courts. Okay. Despite the achievements of the 1990s judicial reforms, the Russian judiciary was still open to manipulation and political pressure. This has led to a trend of authoritarian constitutionalism, especially between the RCC and the executive branch. Between 2001 and 2016, Presidents Putin and Medvedev amended the 1994 RCC Act a total of 15 times, making key changes to RCC regulations, including salary changes, relocations, and age limits to test the loyalty and compliance of the RCC. Alexei Trashev and Peter Solomon have previously written about how the RCC's defense of Russian sovereignty against international judicial bodies is one of their adjustments to Putin's increasingly authoritarian regime. They argue that the RCC engages in a balancing act between two governance regimes, the constitutional regime and the regime of political expediency. The RCC has become a trusted ally in the regime in its defense of national prerogatives against the decisions of the ECHR, European Court of Human Rights, that threaten Russian national interests, and displays judicial pragmatism given their new political realities, such as regime expectations of loyalty. Trashev and Solomon demonstrate that one of the ways the RCC has pragmatically navigated the tension between constitutionalism and political expediency is by presenting itself as an effective defense against the ECHR international encroachment upon Russian national sovereignty. They illustrate how RCC's defense of selective compliance is necessary to adjust to new political realities and preserve some autonomy for RCC judges to continue other important work in expanding domestic judicial activism. Similarly, Halakova has stressed that the RCC has balanced restricted judiciary freedom on politically sensitive issues on one hand, with the greater freedom to adjudicate social rights issues on the other. However, the recent constitutional changes accelerated by the EURUS trials have rendered the duality of the two governance regimes void by firmly subjugating the RCC and other branches of power directly under presidential control. In 2015, the RCC developed and adopted a defense mechanism to check ECHR jurisdiction and applied it to not one but two ECHR judgments, prisoner voting rights in 2016 and the EURUS compensation ruling in 2017. Putin chose to engage the RCC in dealing with unfavorable ECHR judgments instead of simply defying them. Analysts argue that the 2015 decision was largely in response to the 2014 ECHR EURUS compensation ruling, which had incited resistance among the Russian political elite. Though the Justice Ministry's solution was not the most elegant, it was nevertheless technically legal, since the 2015 defense mechanism ranked ECHR authority, and therefore international law, subsidiary to RCC jurisdiction. And since the 2014 compensation rulings, EURUS shareholders and Russian authorities have continued to battle in international courts. In 2016, the Hague District Court shockingly overturned the Permanent Court of Arbitration ruling. And in February 2020, the Hague Court of Appeals reinstated the ruling, which sparked a series of key developments in 2020. In 2020, the Russian executive branch expedited a slew of constitutional amendments. Putin announced them in his State of Union address on January 15th and submitted them to the Duma on January 20th. Both houses of parliament approved them in early March, and by March 14th, Putin signed them into law. These amendments include the official empowerment of the RCC to reject international rulings if they, quote, contradict public legal order of Russia, end quote. The 2015 defense mechanism made Russian selective compliance of international rulings legal. The new amendments now make it constitutional and reflects Russia's aggressive resistance to the EURUS compensation ruling. In October, the State Duma drafted a law banning the publication of dissenting opinions regarding RCC rulings. And in December, the Hague Supreme Court announced in preliminary proceedings that it would not suspend the compensation ruling, thereby permitting shareholders to continue to enforce the compensation ruling pending the main events of the trial and final judgment in 2021. And so the fight continues. Okay, and judicial independence under threat. The constitutional changes had severe consequences for judicial independence in Russia. The 2015 defense mechanism allows the RCC to cherry pick international rulings, solidifying the supremacy of national law and sovereignty over international rulings, solidifying the supremacy. Oh, no, I just said that. Further, technically, now any international agreement or treaty that Russia has ratified can be challenged on the basis of its failure to comply with the Constitution, which effectively renders the fundamental principles of international law and treaty obligations void. It also undermines the ECHR and cheapens the obligations of the Council of Europe to pie-crust promises, easily made and easily broken. The 2020 constitutional amendments. The amendments severely threaten the independence of the judiciary and the constitutional rights and freedoms of the Russian people, reflecting the further erosion of rule of law in Russia. Article 79 stipulates that the decisions of the international organizations adopted on the basis of provisions of international treaties, which in their interpretation contradict the Constitution, shall not be subject to implementation in the Russian Federation. Further, an added paragraph 5.1 B of Article 125 empowers and tasks the RCC to determine the possibility of enforcing international rulings if they contradict the fundamentals of public legal order in the Russian Federation. This vague wording of this amendment makes it instrumental to Russian refusal to comply with the EURUS ruling and other severe international rulings. The amended Article 125, paragraph 1 reduces the number of constitutional court judges from 19 to 11. This will have repercussions on their workload, the efficiency of the court, and the quality of decisions and determinations. Several key amendments also significantly expand the powers of the president to a staggering degree, which I'm happy to elaborate about in the Q&A. The constitutional amendments have formally shifted Russia from a semi-presidential constitutional system where the president remained outside the system of separation of powers to an outright presidential constitutional system. Over the past 2 decades, the president has expanded his executive powers, but the new constitutional amendments firmly place him at the top of the executive branch, both as head of state and head of the executive branch. The constitutional amendments in 2020 signal a re-Sovietization of Russian legislature and negates the initial efforts in the 1990s to commit to norms of international law, principles of democratization, and constitutional rights and freedoms. The amendments signal a clear disregard of international treaties and laws by subordinating them to the interests of national sovereignty. The president has not only significantly expanded his own powers and influence on all executive branches, but has made it far more difficult to remove him of immunity once his presidency ends. In October, the Russian State Duma prepared amendments to the new law on the Constitutional Court to prohibit the publication of dissenting opinions of RCC rulings. So, though RCC rulings are passed on majority vote, some individual judges can publish dissenting opinions expressing disagreement in written form. These carry no legal force, and they're usually added to the case file and published along with the RCC's final decision. Formally, the draft law does not ban dissenting opinions outright, but they are no longer to be publicized and will be accessible only in the archives and out of the public eye. This carries severe legal consequences, especially since dissenting opinions are vital to the principles of open justice and pluralism of opinions. In politically sensitive cases, judges will often write with dissenting opinions. Pertinent to this paper, in both cases of RCC implementation of the 2015 defense mechanism provoked strong opinions. Chairman of the RCC, Valery Zorkin, has argued that the intent is to separate ideological discussion from legal logic. Critics have countered that the two are inseparable and that the entire Constitution is an ideology. It's an ideology of life, of law, of dignity, turnover of power, freedom of speech, and the priority of the individual over the state. Zorkin adds that the judges are not prohibited from writing dissenting opinions altogether, just from publishing them. However, the knowledge that a dissenting opinion will never be available to the public is the best demotivator for writing it. Okay, and Article 125, paragraph 4 has been amended to severely curtail the rights of everyday Russians. Previously, if an individual believed that the legal norms applied in their pending case in court violated their constitutional rights and freedoms, they could refer it to the RCC. However, the amendment conditions this prerogative by now requiring the individual in question to, quote, exhaust all internal state means of judicial protection, and quote, prior to referring their case to the RCC. Exhausting all legal remedies would take years, and so by the time the cases reach the RCC, the reduced number of judges would then slow efficiency and affect the quality of decisions. Coupled with the constitutional ability to reject ECHR judgments, the constitutional rights and freedoms of Russians are under serious threat. Moreover, LGBTQ marriage rights have been directly condemned in the amendments, which call for the, quote, protection of the institution of marriage as the union of a man and a woman, end quote. Okay. In conclusion, the constitutional changes accelerated by the EURUS trials have disrupted the RCC's balancing act of judicial pragmatism with the state by formally erasing the separation of powers between the executive and the judiciary. The new amendments and constitutional changes have removed the necessary checks and balances which allow for a functioning democracy. In particular, the changes directly countermand the efficacy of the RCC and its balancing act by reducing their efficiency, removing their ability to publish dissent, withdrawing irremovability of judges, and setting obstacles to constitutional review of pending cases. Without an independent judiciary and clear separation of powers between branches of state governance, the balancing act has been grossly offset. This bodes severe consequences on rule of law in Russia and threatens the constitutional rights and freedoms of Russian citizens. Thank you.
Thank you very much, Alexandra. I think that paper really supplemented well Arina's paper and gives us really a lot of things to think about, which we'll come back to later in the discussion period. We're going to move, however, directly to Nataliya's paper. Nataliya Bezborodova is a PhD candidate at the Department of Anthropology at the University of Alberta, and she's going to be talking about flying community places in dialogue.
Thank you. Thank you very much. I'll share my screen. Do you see my screen well? Yeah, okay, good. So I start presentation. Yeah, okay, now it's good. I will speak from the lenses of cultural anthropology, so that would be a little bit different from the previous presentation. And I will speak about flying community. So there is a group of people, international and interdenominational. And I will talk about the representation of as a religious group, but also discussing the political turmoil and how they use exhibit as a tool or as a lens, as an approach to talk about their experience. I will start here. Late August 2019, I came for a week to an Italian town of Rimini to continue my fieldwork. This place has hosted the annual Festival Rimini meeting that was organized by Roman Catholic movement Comunione Liberazione, I will call it CL later, for the last 30 years. I came to see a new exhibit created exactly by Flying Community. And Flying Community, who they are, that is a group of people from Ukraine, Russia, Belarus, and Italy. They are Catholics and Orthodox Christian, and they see themselves as one community. And Flying Community brings a very strong interdenominational aspect and challenges usual structure and calendar cycle that developed in the CL, and also address the issues of identity that connected to local histories and cultural context, and also external circumstances of the political turmoil. The community formed ties between this all geographic locality you can see on a map, and also through religious schemes and through current political conflict. In 2019, Flying Community prepared an exhibit about Mother Maria Skoptsova, who was a nun and born as Elizaveta Pilenka in late 19th century. She was from a Russian upper-class family that connected to Ukraine, a poet and a journalist, highly active in politics in her young years. She was married twice and twice divorced, had 3 children from her 2 husbands, and she became a political immigrant in France with her family after the First World War and a nun before the Second World War. She lost and found her faith in connected to the turmoil event in her country and her family circumstances, and all her 3 children died before her death in a Nazi camp in 1945. So she was canonized as a martyr in 2004 by Constantinople Patriarchy, and this canonization received a severe critique from Moscow Patriarchy because her life details did not fit the typical image of a saint, as being divorced, having children from different men, and also she was a heavy smoker that also was kind of criticized. The exhibit preparation was assigned to 6 locations of flying community in Ukraine, in Russia, Belarus, Italy, and for this particular exhibit also in France, to be pulled together in Rimini. Many members admitted that they had not been involved in this work to the same extent as they did before to other exhibits. But in Rimini, they revealed connection of Mother Maria life and the current context of their countries in post-Soviet places. So this exhibit had messages directed both inside to the community and outside to the visitor of this festival. The exhibit guides emphasize 2 metaphorical images when they go through the exhibit. There was water and fire, water in the beginning of the exhibit and fire at the end. Water was one of Mother Maria metaphor in her worldview. So she defined 2 types of people life strategies. One is ground-based and what well-planned ahead and material-oriented life. And another one that she called as water walking. So that is a strategy that means responding the everyday needs, everyday challenges in turmoil and unpredictable situation. And of course, water walking image built connection to the biblical narrative and to supernatural presence. Also ground and water symbol explaining her own life, as she started as a political activist from an upper class family and ended up as a nun in a concentration camp. Fire was a direct quotation from her writing, so exactly that was the phrase used for the exhibit. Christianity is either a fire or there is nothing. And what exhibit guides explained as a Christian position in any life challenges that not always comfortable, and it should not be always comfortable. And water and fire as a symbol appears in the flying community narrative not for the first time for me. I have heard them also in 2014, 5 years ago, in connection to the Maidan protest in Ukraine. And according to my respondents, the formation stage of the flying community that happened exactly with the protest in Ukraine. So the Maidan event, I was briefly remind that 3 months anti-governmental protest against that President Yanukovych in late 2013, early 2014, who changed his decision to connect to the European Union, to sign an agreement with the European Union. And after that, a Russian-Ukrainian conflict evolved. On January 19, usually, so that is a special day in the calendar, Orthodox Christian in Ukraine celebrate Epiphany, and that involves outdoor ceremony of water blessing in lakes and rivers outside, and also local tradition includes ice hole diving on that day. And on January 19, the members of flying community met for the first time in winter in Lishnya. So that is a special place. That's a few pictures. Lishnya, there is a village about 1 hour drive southwest from Kiev. And this is a place that hosts the summer theological school for about 10 years. And for 2 weeks, those people who were regular members, they started to be, they knew each other as a student of that school. But that was their first meeting in winter. So they came together to celebrate Epiphany, and that was the day of the first very hard escalation on the Maidan that caused first death among protesters. And media called that day as a flaming epiphany. And one of the Belarusian members articulated in connection to the protest of Ukraine how important that was. So he said that our totally, I quote, our totally new wave of story is inevitably tied with the Ukrainian Maidan. It is like not only for Ukrainians, not only for those who had place experience, it is very much connected to me personally. I totally went through all that. It is very important for me not to forget and not to lose that moment that everything that we have was born from that pain. And we received such a great opportunity in this seeming catastrophic situation that still did not finish and not going to come to the end. So in August 2014, Flying Community presented, that was their first exhibit at the Rimini meeting, and it was focused on the Maidan events. The exhibit attracted many visitors in Rimini, and many young Italians visited Ukraine after that, and Flying Community established their activities on a regular basis. So that was summer 2014. And a few months earlier, the conflict evolved in Ukraine. So where we have right now the escalation on the very east, Donbass and Lugansk. And in spring, in March, the group of Flying Community connected in Kharkiv was to celebrate Easter. And that was the moment when Kharkiv situation was very unstable, and it could become the third spot of escalation as well, the same as Lugansk and Donetsk. And one of the guests invited from Italy had an idea. He suggested to organize a pilgrimage to Jerusalem as a way to reconnect. So that is a highly symbolic place for all Christians, and they see that as an probably the most possible way how to reconnect the community together, because between Russians and Ukrainians there was already tensions, and they had somehow to overcome. And this pilgrimage bring two exhibits that toured very intensively in Ukraine, Russia, Belarus, Italy, and the UK. So that was two exhibits about their leaders, one from the Orthodox side and another from Catholic side. But the third, Mother Maria Skoptsova, that came later. And so to me, that was a question how that was connected. And because the political conflict also triggered changes in religious situation in Ukraine. In 2018, Ukrainian Orthodox Church received independence from Constantinople Patriarchy, so that's from Greece, and it evoked the split in the Orthodoxy between Moscow Patriarchy and Constantinople. So if we look back in the history, the presence of Greek in Ukraine started in 10th century, and they were kind of predominant until the 15th, for 5 centuries. And then with the period that Moscow Patriarchy, the tension started, but it was not, it was never so open as that year. And the protest from Russian Orthodox Church was concluded into interrupted liturgical communion. And in the church language, it is the highest level of conflict. It can happen only in exceptional cases, and some theologians compare that situation with the historical schism between Orthodoxy and Catholicism. So in this way, Flying Community had the complexity as a group, as kind of a new split, a new schism that they have to overcome, because when excommunication is announced between denomination, their individual members cannot participate, so they are not allowed to participate in any sacrament together. And that threatens to split the community again. And this situation put Flying Community in Ukraine and in other countries before a very difficult choice between the churches that took the opposite sides in the political and religious conflict, and celebration of the sacrament together and their family members and others. So in this way, I see that the community found a way to making ties over possible division through preparation a guiding exhibit as a spatial tactics and heterotopias that, according to David Picard and Michael Foucault. In particular, Picard states that this type of mediation assists people to go through significant points of their life cycle, such as the shock of migration, environmental disaster, political unrest, or other forms of life crisis. And heterotopia is a term about places where all other real sites can be found within the culture that simultaneously at the same time represented, contested, and inverted. According to him, those places are museums, historic villages, cemeteries, gardens, and theme parks. And exhibits and festival have similar feature with the listed, so also as another cultural practice. And heterotopia is one of the spatial tactics where space is used as a strategy or technique of power and social control. And another researcher, Tammy Gordon, who studied small museums and exhibit developed in private initiatives in the USA, noted that community exhibit is first of all a social practice that allows strangers to discuss their own views with one another. So they kind of provide space. Its function is to promote individualized perspective to strangers and cement ties between relatives, friends, colleagues, and community members. This type of exhibit serves to explain communities, families, and individuals to outsiders, and also to tie insiders together as a shared narrative of historical experience. And one of my interviewees, Constanza, Roman Catholic, currently converted from Orthodox. She was born in Moldova, close to the border of Ukraine, and moved at the age of 12 with her mother to Italy. So she met flying community at the Rimini meeting in August 2014, when she volunteered to translate guiding tours on the Maidan exhibit. She said, in quote, I knew almost nothing about those people from flying community. But because I translated for them, I could practically know everything about a person within an hour. Everything is clear from what a person talks about or how or she or he narrates. It was not just an exhibit, and the person talked not about the exhibit, but about ourselves and themselves. According to Gordon, also community exhibits are often created to tell about neglected histories that matter to people, about those aspects that were missing in other narratives, other known narratives or popular narratives. And the exhibits narratives often are personal, based on feelings, beliefs, and memory. And this exhibit of flying community served as a communicative approach between two different religious traditions, in addition to different cultures and multi-locality and coexist in one religious movement. Also, I would like to add that, repeat after Gordon again, that these exhibits are the sites of cross-class, cross-ethnic, cross-cultural conversation that ultimately lead to social and economic change. So I'm still working and continue work on the collected material through my field work. And I would be focused more on the meaning of space, on the meaning and tools that the people pick up to overcome the difficulties. Thank you.
Thank you very much, Nataliya, for the very interesting presentation. So thank you to all of our four presenters. You stayed wonderfully within the time. So we have a little bit of time now for discussion. And I'm just going to start off with a few comments / questions, and then suggest that perhaps we take questions immediately from the audience as well, and then give each of the presenters a bit of time to respond. So if you presenters would just note down the questions so that you can respond to them a little bit later. So starting out with Arina's paper, I found this a very good overview of the decentralization process. Just one little factual comment, which is, of course, that in 2012, the gubernatorial elections were reinstated in Russia. So you might want to build that into your picture a little bit. I thought that it was interesting that you started out with this distinction between rule by law and rule of law in your historical account. And it made me think that it would perhaps be helpful to define the notion of rule of law even a little bit more carefully, what exactly that concept implies, and how you would distinguish it by something like rule by law, which has a different connotation, not so much of rights, but as one of control. Because my impression was that rule of law, the impact of these centralizing movements for rule of law implied a greater capacity of the state to use law for its own purposes, but a lesser capacity for civil society or citizens to turn to law for their own protections. And maybe sort of unpacking a little bit those different dimensions of rule of law could clarify that, and of course link it to the theme of our panel, which is civil society. The other question I was going to ask, but to a certain extent, I think it was touched on by the next paper, was that you didn't talk about the role of the courts, which I think is critical to any notion. Could you turn off mute your
and the UK.
Mute your microphone if you could. Okay, thank you. If you could, the courts, of course, are critical to any notion of an independent concept of law that stands equal, where everybody stands equally before the law. And although it was touched on in Yao's paper, it might be interesting to think about it a little bit in terms of the federal relationship and how the courts have also been brought into this in terms of the way in which centralization in the sense of the federal system relates to this rule of law movement. So those would be a couple questions I'd have for you. And then moving on to Yao's paper, which I found also to be very interesting and to supplement the first paper, the link between the European Court of Human Rights and these movements toward establishing the ability of the Russian Constitutional Court to put itself above the rulings of the European Court of Human Rights based on contradictions with the public legal order. I was intrigued. I mean, it seems like that was triggered by the EURUS decision, which is a little bit puzzling because you might think other things would be more challenging to the Russian state than the EURUS case. Of course, it had a big financial element to it, that ruling did. But it made me wonder, well, one thing that I observed was it appears the appearance of legality is very important to the Russian state, and the efforts that have the states gone through to try to be able to make the argument that what was done was constitutional and legal. And I was wondering if you could reflect a little bit on that as to why that's so important to this what you're calling an authoritarian constitutional order. We often think that legitimacy is maintained through elections, but here you're kind of arguing that an appearance of legality, even legality in terms of an external actor like the European Court of Human Rights is very important. And it's also interesting in what cases that provision is actually invoked. I mean, I'm thinking now of the Navalny case. Maybe it doesn't need to be invoked there. Of course, he also went to the European Court of Human Rights. And I don't believe that provision was invoked there, maybe because it could be dealt with in other ways, simply by rerunning the process and in that way being able to give him a sentence. But it would be perhaps the next step to look at how, in what cases the court actually uses this authority, and how the president, you mentioned this, I think, as something else you've looked at, other powers of the president to actually control the way that the Russian Constitutional Court makes these decisions. Does this mean that the Russian Constitutional Court has lost its capability to make independent decisions, or does it simply mean that there's another legal principle that's been applied? Because I do believe that there are at least a couple other cases where national authorities have invoked a similar principle in terms of dealing with European decisions of the European Court of Human Rights. So I learned a lot from that paper, and I thank you very much for it. I think it reflects a lot of very interesting research work. I'll move on to Nataliya's paper. We're going to quite a different topic here, so it's quite a transition. It was certainly a very interesting paper or presentation that I knew absolutely nothing about. It does link, I think, to our thematic of civil society, and I wanted to link it this way because I wasn't totally clear on the purpose of this flying community. You talked about its connection to the Maidan and how that seemed to both galvanize the movement, but also then, because of the division within the Ukrainian Orthodox or the Ukrainian Church, lead to some potential for problems. But is this really an effort to develop some kind of transnational civil society? Is that what it's all about? Because as I say, it wasn't clear to me what the underlying purpose was. Does this have a political purpose? Is there a concept of some kind of international civil society here that's underlying this? And how is that linked to the kind of religious basis and religious justification? So perhaps you could, if you have time, you can clarify that for us a little bit, just to link it a little bit back to the theme of the panel. And finally, Grigori's presentation, which I found to be very interesting. I mean, this is a topic that, as my students know, we frequently discuss in our seminars. How should we define civil society? And the fact that even in the Western literature, there's a lot of discussion about whether the Western definition should be applied to the Russian context because of differences in history, context, and meaning that people in place give to the idea. And I think you draw out very well these elements that you've derived from Putin's speech. So a couple of questions. How much of this definition that Putin is putting forth is instrumental or I think you called it perhaps ideologization of the concept, and how much of it is really rooted in a kind of embedded cultural understanding. If it's the latter, to the extent that it's rooted in a kind of embedded cultural understanding, just because of the differing role of the state in Russian society historically and currently, this would suggest that it's a kind of a contested concept, that there's no generally agreed upon meaning of the concept. There's a Western definition. There might be a kind of, definition that emerges out of other cultural contexts, which has a different take on the relationship between civil society and the state. And if that's the case, to what extent are those definitions compatible? And what does it mean for Western researchers who are investigating Russian civil society? Should we continue to apply a Western definition? Is that appropriate? Or should some kind of account be taken of the fact that not only for instrumental reasons, but also for kind of cultural historical reasons, the way that civil society, or that some variant of that concept, some equivalent of that concept, is conceptualized in Russia may be different, and therefore it may not be appropriate to apply a Western definition when trying to understand the way that civil society relates to the state. So I'll put that question for you on the table. And if you just take note of those, I'd really like to also give our audience a chance to ask any questions. So if there's anyone in the group who would like to pose a question now, you could do it. Otherwise, I'll go back to the panelists and ask them to respond and give you a little bit more time to think about that. It seems like we pretty well run out of time. I don't see any other questions. Thank you to all of the presenters for your answers to the questions. And I'd like to remind you that there will be the keynote talk this evening at 7 p.m. by Alison Grant, Director of Eastern Europe and Eurasian section of Global Affairs Canada. So I hope that you'll attend that. And again, thank you to everyone for attending and for this excellent panel to our presenters. So see you all later, and thanks a lot. Bye.